Good afternoon, I'm Nalini Mahadevan, and we are here today with top 10 questions that our estate planning clients ask us. So we are a law firm, MLO Law. We are located in Clayton, Missouri, and we specialize in immigration and estate planning and elder law. So today the topic, as I told you, is the top 10 questions that most of my estate planning clients ask, and I thought I'd answer them for you. Let's see. Question number one. Powers of attorney. So a lot of clients come in and would say, well, I have this power of attorney and my mother died. Can I use it? No, you cannot use it. A power of attorney is only valid as long as the person who signed it is alive. Even if they're incapacitated and they cannot make a decision, that power of attorney is still valid as long as it's not being taken back by the person who signed it. The second question is, do I need a will, or isn't a will enough? So yes, you need a will. Everybody needs a will. The will is what the will does, it's a document that tells a court, I passed away. Hey, I passed away. I'm appointing this person to represent me. And that person in the state of Missouri is called a personal representative. So much like the executor you see in all the movies, that's the same person. In Missouri called a personal representative. That person will represent your assets, everything that you have in your quote unquote estate. That means everything that you own and you owe to other people. They'll represent that, and the court will give them the power to gather all those assets and to sell them or distribute them to whom they have to go to. So the other thing the court does with the will is to appoint guardians for minor children under the age of 18. Also, you can use it to appoint guardians for people with special needs, but the special needs guardian has to be appointed by the court. A guardian for a child under aging has to be appointed by the court. It's not enough to say so and so will be the guardian. And lastly, if you have left something only in your name, or you and the co-owner, who may be your spouse, has passed away, then that title has to be retitled to the person to who's going to receive it or inherit it. So the will has three functions: naming a personal representative, appointing guardians, and retitling assets. Another question is, if we all die, who will get our assets? Who will get everything we own? Well, if you all die, in general, most documents will say to our heirs at law, which means that if there's a husband and wife and the children pass away, either the parents who are alive will get it, or the siblings of the husband or the wife will get it. Or if there are none of these present, then the children are also passed away, the grandchildren could get it. And if there are no grandchildren, then maybe more remote relatives could get it. And if there are no remote relatives, then it'll go to the state. Is the will the same as a living trust? No, they're two separate documents and two completely separate functions. So the will is, and also it's also, by the way, confused with a living will. So the will is very different from a living will, is very different from a living trust. Three very different things. The will, as I said, is a direction to the court. It has to be filed with court. A living will is your direction to say, what is going to happen to me when I am at my end stages of life? What do I want to happen? So a living will say, stop feeding me, or do not do any more invasive procedures, or if a doctor says that I am in the end stages of life, the person I have named as my power of attorney holder for healthcare can make the decision to say to end my to in common parlance pull the plug. So you are giving permission to people for people to do that. Sometimes in our practice, we tell everybody you may have the decision to do that, but we give a breathing space of 4 to 5 days before the final decision is made. And that gives everybody some breathing room to come to peace with the decision that they have made, especially for loved ones. Finally, a living trust is very different from a living will. It's very different from a will. A living trust is a trust you make while you are alive. It's an agreement between you and yourself. And you decide that I'm going to rename my assets to the name of the trust so that the person who succeeds me in administering the trust, who's called a successor trustee, can come in, gather all the property when I have passed away, and either give it to the persons who are supposed to get it or sell all the property and distribute the money, whatever your instructions are. At this time, I think Jamie tells me we are at 7 minutes. So there are about another 5 questions left. I am going to give that to you in another video, which we might post in a couple of weeks. So look out for that. The next 5 questions about burning questions about estate planning, which we answer our clients, answer to our clients every day. All the best anyway. If you want to get in touch with us, we are at 314-932-7111. Jamie picks up the phones. You can email us at nsm@mlolaw.us. That is also our website. I will see you in our next video. Thank you.